This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we speak about why a court found insurance agents' E&O policy was unambiguous and why an exclusion for suits between insurance agents in an E&O policy was appropriate and established. In a case entitled Laurence Ziff, individually and the Ziff agency versus Allianz Global Risks, the United States District Court for the District of New Jersey on September 23, 2025, found that Laurence Ziff and the Ziff agency were insurance brokers, sued Defendant Allianz Global Risks U.S. insurance company for defense and indemnity to a lawsuit alleging defamation. Plaintiffs had purchased several insurance policies from Allianz, including the policy at issue, which provided company-sponsored life insurance agents' errors and omissions liability coverage. The lawsuit by David Plotkin and Richard Urbealis sued plaintiffs in New Jersey State Court, alleging defamatory statements made by Plaintiff Ziff during a meeting related to the sale of life insurance policies. Defendant Allianz denied coverage based on Exclusion K, which disclaims liability for any claim arising out of disputes with other insurance agents or brokers. Defendant filed a motion to dismiss the amended complaint for failure to state a claim under Federal Rules of Civil Procedure Section 12b-6. The court found that Exclusion K was unambiguous and applicable as it excluded coverage for disputes between insurance agent and brokers, including those concerning commissions, fees, and client lists. The court, analyzing the issues in the law, found that exclusionary clauses in insurance policies are narrowly construed. The insurer always has the burden to prove that an exclusion applies. If there is more than one plausible interpretation of the language, courts apply the meaning that supports coverage rather than the one that limits it. However, if the words used in an exclusionary clause are clear and unambiguous, a court will never engage in a strained construction to support the imposition of liability. The defendant Allianz argued that the Plotkin lawsuit was a dispute between insurance agents and brokers, and therefore Exclusion K applied. Plaintiffs conceded that Plotkin and Urbealis are insurance agents, but contend that the Plotkin and Urbealis did not sue plaintiffs as insurance brokers or insurance agents, and did not act as insurance brokers or insurance agents in the placement of the life insurance policies at issue. Contrary to the allegations, the record clearly demonstrated that Urbealis and Plotkin were acting as insurance agents when trying to sell life insurance policies to a person by the name of Kurtz, since the language of Exclusion K was unambiguous and applied to this litigation. The plaintiffs were not entitled to coverage under the policy and failed to state a claim upon which relief could be granted under Rule 12b-6. Defendant's motion to dismiss was granted because a court may dismiss a claim with prejudice when leave to amend would be futile, because plaintiffs failed to identify any way in which they would be entitled to coverage under the plan. Amending their complaint for a second time would be futile, so the case was dismissed. In my opinion, insurance policies are contracts whose terms and conditions, when brought to a court, are interpreted by the court. The Allianz policy excluded disputes between agents and brokers in language that was clear and unambiguous, and the dispute was also obviously a result of claims made by insurance agents or brokers against the insured insurance agent. So no coverage was obvious. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 5,150 blog postings. Please tell your friends and colleagues about this blog and the videos on YouTube and rumble.com so that they too can subscribe. They're free. And if you or your friends and colleagues are interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.